Hi, everyone. My name is Naomi, and I am the program director, adult education director at the community center at Visitation. We are located in Kensington, in the intersection of Lehigh and Kensington Avenue. Our adult education program is a brand new program that we are building up, and we rely on the community support to really shape that program and understand what the needs are for the program. We are currently working with many organizations like NKCDC, legal services, Christian legal services. And the reason we are here today is because we feel like in the community, there are many questions, unanswered questions around the laws, around other topic. So today we have with us Kelly Fratamico. Did I say it right, Kelly? Right. All right. So she is a member of the Christian Legal Services. She can say more about the organization. And I believe I saw Jamie. I'm not sure if she's still here with us. But also another member of the Christian Legal Service. So the presentation today will be about family law. So if you have any questions at the end, there will be the presentation. And then at the end of the presentation, if you have any questions, we can discuss the questions. And so because there are many people that are interested in the topic, but we're not necessarily able to be in the meeting today, we will be recording only the part of the presentation. So feel free, if you have like questions that are more sensitive, to ask them at the end, because we will stop the recording at some point, and then you will be able to freely ask your questions. I think that that's it. And Kelly, microphone is yours. And I hope you enjoy the meeting.
Well, hi, everyone. My name's Kelly. I'm the family law staff attorney at Christian Legal Clinics. CLCP is what we call Christian Legal Clinics of Philadelphia. We have clinics throughout the city in which volunteer attorneys meet with clients for a free 1-hour consultation regarding whatever issues they may be dealing with. If it's a family law issue, it usually gets referred to me, and I'm able to continue to assist families going forward, whether it's a custody, child support, that sort of matter. We also have volunteer attorneys that handle a variety of other issues, probate, wills and estates, as well as expungements for criminal records. And if at the end, if that's something that you all may be interested in learning more about, maybe we can do that in the future, like an expungement or a wills informational session as well. But today is going to focus on family law, which is my area of expertise. And so but one thing that I'm hoping this presentation will assist all of you with is to demystify the legal process. Each individual person knows their story and what is best for their children and their families better than any attorney. And what they call pro se in the legal language is essentially representing yourself in court. And it's something that I think with a little training and coaching, a lot of people can do without needing the expense of an attorney. So that's what my goal is of today, is to kind of show you as the individual how you can take charge of your own family law situation. So if everyone's coming, I'd just like to start today's presentation with a quick prayer. Dear Heavenly Father, thank you to Community Center at Visitation for offering us this opportunity to talk with individuals and learn a little bit about their story. And I hope that we are able to assist in our small way. In your name, amen. Okay, so give me one moment while I bring up our PowerPoint, and then we can get started. Sorry, my laptop's a little slow.
So while the presentation is loading, if everyone could type their name in the chat, and if they come from an organization, they can put that also in the chat just for attendance purpose. Thank you.
Sorry, my computer just keeps spinning. Oh, here we go. Well, I thought we were ready.
Happens, technology.
There we go. All right. So the first thing I thought we'd talk about is, okay. Is a petition for custody. And you can file again on your own. If you have a custody issue with your children, you can go to the 11th floor of the Domestic Relations branch of the Philadelphia Family Court. It's at 1501 Arch Street, Philadelphia, PA. And you can go up there and you can file for custody. You can fill out the paperwork ahead of time, and I can show you.
Kelly, are you sharing your screen?
It says I am. It's not sharing. Okay, give me a sec. I
can't see it. No, sorry.
Okay. Okay, is that better? Can everyone see?
Yes, it's working.
Okay. So what I just sent us to is the www.courts.phila.gov, and you can go on as a individual onto that website, and they have all the forms that you would need to fill out if you're interested. And if you're interested in filing for custody, and what those, and you can, I was trying to bring it up so you all can see the form. Here it is. And you go to what this is, Court of Common Pleas, Domestic Relations. Click on that button, and you can pick from the category of what you're interested in, whether it be child support, custody, divorce, protection from abuse. All of it is included in there. So we're going to go to custody, and these are all the forms that are required that you may be interested in, from a petition for emergency relief, complaint for custody, modification of custody, all of that. So and really you can just print it out, fill that out as an individual, write your story, and go to the 11th floor and file. And now go back to our presentation. Now, if you're filing what they call pro se for custody, you'll need to include 3 forms. The first one would be what we just talked about, the actual complaint for custody, and you can get all these forms on that website. The next one is a criminal affidavit, in which it goes through there's numerous criminal offenses that are listed, and you have to check off if any of those apply to you. They're pretty extreme. I mean, they look for abuse and neglect regarding children, violent assault, and violent crimes, essentially. So, a lot of times people get hesitant or fearful when they see a criminal record affidavit. The court understands that we're all imperfect people. If you have a marijuana charge, a drug possession charge for 10 years ago, it's just something the court wants to know about. Don't let that inhibit you from filing for custody or thinking that it's going to prohibit you, because it won't. It's just something that the court wants to know about, and that you should be prepared to possibly address at a custody hearing. Talk about how maybe it was a part of your past, but how it's not affecting you now in the future for your child. So that's something to include. And then the next thing is a domestic relations information sheet, which goes through, your current address, the address of the other parent who you'd be filing for custody against. And and also and telephone numbers. It's essentially so that way the courts can serve the other party when you file. So it is expensive. I believe it's like $350 to file for custody. If you are financially strained, you can file something called an informa pauperis, in which it's another motion that you would be, and this form is also on the website that we previously discussed. So you can go on there, fill it out, in which they ask for financial information, employment history, and if you qualify that you are under a certain income level, it will waive your fee for these filings for custody. Okay. So the custody statute is 23 PA CSA 5328. And this is the statute that all judges look at and consider when determining custody. And it's numerous factors that we'll go through one by one together, and we can kind of talk about why these factors are important and how the court looks at it. Another thing to mention is that a while, not that long ago, even like 10, 15 years ago, the courts were very weighed towards mothers getting primary custody, but that's really changed. Now the courts really do try to give split true shared custody with fathers, real 50-50. Does that always happen? No, but the statute now is trying to, if possible, really do true shared custody between both parents. So the first factor that I thought is important to talk about is which party is more likely to encourage and permit frequent and continuing contact between the child and the other party. So what that means is the court wants to see, is going to give more custody to the parent that's willing to cooperate with the other party. So it's pretty much encouraging civility between two parties from the very beginning. The court understands that partnerships, intimate partnerships end all the time. And it's important, but it's best for the child that the parties get along. So the parties, meaning mom and dad, get along. So the court really looks favorably on giving custody to a parent that frequently reaches out to another parent and says, hey, would you like to see our child on Friday? Hey, Nathan has a soccer game on Saturday. I know that's my parenting time, but if you want to come, that's fine. That sort of civil behavior is really looked favorably on the court. And text messages, emails, all of that is admissible evidence in court, as well as what you post on Facebook. So, the court really looks at that. If you have text messages and email exchanges that show that you're really trying to work with the other parent in the best interest of the child, that weighs very favorably in getting a true 50-50 custody. I certainly understand that is not always easy when there's a lot of emotions and pain involved with regards to a child. But I always encourage any parent, if they really want to increase their parenting time and get a shared schedule, to be as civil and kind to the other party as possible, because that is something the court really looks favorably on. The past and present abuse committed by a party. The second factor is the present and past abuse committed by a party or member of the party's household, where there's continued risk of harm to the child or an abused party, in which the party can better provide adequate physical safeguards and supervision of the child. So that means that there's a history of domestic violence in the home, especially if it's, there's evidence for that, whether there was a protection from abuse order implemented, that the court is going to look at that. That is a factor that they consider of, if the party that has a PFA may not be in the best interest for the child to spend a lot of time there. Or if for drop off and pickup times, it should be in a secure location, not a parent's address. So those are things that the court looks at. As well as significant others. So this applies if mom got a new boyfriend, which they call paramours. If mom has a new paramour and he has a criminal history that involves a violent crime, that would possibly put a child at risk, or if that paramour has had child welfare involvement in the past, those are things the court will look at when determining custody. The parental duties performed, that the court looks at, like, who has been when the marriage or cohabitation relationship was intact, which parent did the primary parental duties, making breakfast, nutritional needs, doctor's appointments. With regards to this factor and dads, I always encourage fathers from day one to be involved, know who the pediatrician is. You can call, get medical records. Even if you're working and can't go to the doctor's appointment, be involved with that aspect of the child. If there's a parent-teacher conference and you can't make it, call in. Because that's something I've seen sometimes mothers rely heavily on, that they've always been taking care of the kids. So dads, if there's a separation, start doing those things. Show the court that you're an involved parent. You're not just having the mom take care of the child, and vice versa. Obviously, if it's the dad's been the primary caregiver, and there's a separation, step up as much as you can. And really just knowing who the child's pediatrician is, when the next doctor's appointment is, what school they're looking at, if they have an IEP, an individual education plan, know about it. And that really does look favorably for the court. Availability of extended family. If, essentially that just, they look at, well, dad or mom work full time, and they don't have anyone to help if the child gets sick at daycare, that sort of thing. That's where that factor comes into play. And relationships with siblings. So if, let's say, there's half siblings involved, the court may offer more parenting, may think it might be better for dad to have more parenting time if the child's half siblings live with dad full time. So, all right. The child's preference, from what my experience has been in Philadelphia, it's not, the court doesn't look at it too strongly before the age of 13 or 14, due to the fact that, a child's maturity is just not at a mature level where they can say, oh, I want to live with mommy, I don't want to see dad. The court understands that children make rash decisions, and children are influenced by things that really shouldn't be influenced on the court. Maybe dad has more rules than mom, so child saying, I want to live with dad all the time. Now, once they're over the age of 14, the court does look heavily on a child's opinion. Not completely, they still obviously understand that there's other factors in play, but the judges will want to talk to the child, get the child's input, and see why the child feels the way they do regarding who they want to live with. Now, factor number 8, the attempts of a parent to turn child against the other parent, except in cases of domestic violence, because obviously that's a whole other factor of manipulation and control. And this one kind of ties into what we talked about before, as far as you want to be civil with the other party. The court doesn't want to see a parent talking badly about the other parent, or telling a child, oh, your mom is such a drunk, I can't stand her, that's why I left her. Those sorts of comments the court is going to look unfavorably upon, and be concerned about the child spending a lot of time with that parent. And where that really comes, and it's called parental alienation. And that's something the court will look at. They'll want to see that the parties aren't trying to alienate the child from another parent. And again, as far as how that's established in court, it's text messages, emails, testimony, obviously from the parent, as well as anything that's posted online. So if you do know that your relationship is fractured, and you're probably going to separate and need to have a custody, be very mindful of what you put in writing and post on Facebook or Instagram, because all of that is admissible. And if you want to file for custody, and you feel like you can do this pro se, and you go forward and file, I always recommend people, print out those text messages. If there's a text where you ask to see your child and dad said, no, I don't want to share, you can go away. All of that's important evidence, and print those text messages out. You'll want to make 3 copies of anything that you intend to show the judge. You'd want a copy for yourself, a copy for the other party, and a copy for the judge. Okay. And the other factor, 9, 10, and 11, which you can read yourself, really just, again, shows if the child has been talking to the other parent, those kind of emotional caregiving opportunities. The level and a cooperation, and you can see 13 13, again, really talks about the parties willing to cooperate with one another. The court just they really drill it in with the statute that the parties should work together as much as possible. 14 is a history of drug or alcohol abuse. That's a factor the court looks at. But if you have had a history with drug and alcohol, don't have a, worry that that means, oh, I'm never going to get custody. I always encourage the judges like to see honesty. If a client goes in and says, yes, for 3 years, I was addicted to opiates, but I sought treatment, I'm clean, I'm willing to take a drug test today and to continue to take one in the future if the courts want me to, and I'm embracing individual therapy. That would get it covered, honestly. I mean, that's something the court's not going to hold against someone. You can have, if you have a history of struggling with drug and alcohol, that doesn't mean you can't be a wonderful parent. And that same thing goes for any mental health issues as well. So when you file for custody, it's a two-step process in Philadelphia. First, you will go to what is called a hearing officer. And a hearing officer asks both parties basic questions to try to get a history of what's been going on with the family. And then the hearing officer will issue an order. Sometimes it will be an interim order before it goes before a judge, and other times it can be a permanent order if the parties are okay with it. And when you first go in to see the hearing officer after you filed, they ask some pretty much like script questions that you should be prepared to answer. And you can go, and these are the ones that I've jotted down over the time that I've been doing this, that I frequently hear hearing officers ask clients, or that clients have informed me that they've been asked by a hearing officer. You're welcome to read over. Essentially, it goes through the factors that we just talked about. They want to know if you've tried to see your child and the other party has not allowed you to discuss those types of events. If there's a history of domestic violence, if DHS, child welfare, has been involved in the home, where do you live, how far are you from the other parent, your location-wise, criminal history. So, when you're in court, especially if you don't have, before a hearing officer and you maybe don't have an attorney and you're feeling really anxious about the process, these are good questions that you can think to yourself and get answers prepared ahead of time so you go into court feeling confident. Some of these questions can feel really invasive. My best advice is just be honest. The court always will look more favorably on someone being upfront with any issues they've had than if they don't come forward. And again, it goes through mental health history in the family, drug and alcohol problems, and also I know your kids. I've had dads I've represented some moms in custody disputes where the hearing officer has asked the father, what's the name of the child dentist? What's the name of the child's pediatrician? And the father can't answer. That, not that dad hasn't been involved, they just didn't think they needed to know that information, but it can look unfavorably upon them in court. So just prior to your court date, think about those things, get that information ready, so you go in with quick answers. And also be prepared to answer some questions regarding supervision in your home. If you're working a lot, let's say you have an 11-year-old and they come home off the school bus at 3:30, you get home at 7:30, be prepared to answer a question of like how you would handle that supervision. If you are awarded that custody time, have something set up ahead of time. So that way, like, let's say mom's been having 80% custody. Dad wants a modification in that and wants true 50-50, but dad works till 8 p.m. every night, the child's done at 3. Dad should come into court prepared to tell the judge how he intends to handle that supervision time. It can be as simple as saying, I've already found a local daycare that does after school programs and I will be able to enroll my child and pay for it. That will look great in court. Be prepared if you are angry at the other party, which is completely understandable in these kind of painful family situations. Definitely try to be as calm and civil as possible. The courts, especially in Philly, are so overwhelmed. They don't want to be involved. They want to be involved as little as possible. So again, if you go into court and say like, I'm willing to communicate with mom, I'm willing to try to negotiate situations that may arise in the future, that will likely result in increased custody time. So this is kind of what we talked about already. When you first file an initial custody or a modification in custody, you go before a hearing officer. If the hearing officer will, like we said, issue either they'll do a final order. If they'll issue an order, if both parties agree on it, then it would become a final order. If they go before the hearing officer and it's really and no one's coming to any kind of an agreement, then they're not even going to issue an interim order. They're just going to send it straight to a judge. Another option another thing that can happen is that they still submit an order, and the parties don't agree on it, or one party says, no, this isn't what I thought was going to happen. I don't like this. I want it to go to a judge. Then you would file exceptions, which is essentially an appeal. And but in order for you to file exceptions, you need to note that it has to be an error in law or fact. So if, let's say, the judge gives mom and dad 50-50 custody. Mom wanted to be the primary parent and dad only have every other weekend. She can't file exceptions and have it brought to a judge unless there's been an error in law or fact. So an error in law would be, let's say dad had a criminal history against a child for reckless endangerment. And the judge and the hearing officer didn't even think about it, didn't mention it at all during the determination. Well, under the custody statute, there are required under law to take that into consideration and discuss it as far as determining custody. That would be an error in law. An error in fact would be that a parent straight up lied during the hearing. Let's say they said, no, I live alone. I don't have anyone in the home with me. My child would just be me and my children during my parenting time. And that's a lie. Let's say they're living with someone who they have a new paramour who has like an outstanding arrest warrant for possession of narcotics. And the other party didn't disclose that or talk about it. And you subsequently, after the order's been issued, discover evidence showing that this is the case. That would be an error in fact that would warrant a filing of exceptions and a change in the order. Does that make sense to everyone? You're welcome to, if it's a little confusing. Okay, so this you can read over a little bit yourself, and if anyone wants a copy of the PowerPoint, I'm sure Naomi can make it available. So these are kind of some sample language that I like to put into custody agreements that discuss both shared legal and shared physical custody. So shared legal means that both parents have to cooperate together in making any kind of decisions regarding a child's medical, educational, or other some primary medical and educational decisions, as well as travel, passport, that sort of thing. And with shared legal, you have to cooperate. So a mom can't unilaterally put a child into virtual school without discussing it with father and seeing if that's something that he agrees on. So you can read through that and just kind of get a grasp of some of the language that I like to use. That if you are trying to come up with a custody agreement, make sure that you know your rights as far as legal as well. So for shared physical, what they do, they will say things such as primary parent and partial physical. So if you're the parent with primary physical custody, that means you would probably get the child between 50 and 70% between about 70% of the time. And the parent with partial physical custody would get the child, let's say 30% of the time. And then there's also shared physical custody, which is a true 50-50 schedule. I've seen true shared physical custody. You may want to request, if you go to court filing for custody, you can tell the hearing officer, hey, I want shared physical custody. I want 1 week on, 1 week off with mom. That situation is usually granted if the parents get along well and there's within 20-minute driving distance of each other. So school will not be interrupted for the child. You can also go into court and request that you be the parent of primary residence That schedule is usually set up that the parent who is not primary gets the child every other weekend, as well as perhaps one overnight during the week. And that is usually granted in situations where the other parent is working a lot, and the parent that got primary has always been the major caretaker for the child and has the availability of time and emotional resources to be able to take care of the child the majority of the time. The other thing to think about when you're filing for custody are holidays. There is a holiday schedule that I wrote out in here that if you are going to file, you're welcome to reference. And it just talks about how it's usually like mother will get all the odd years of holidays, father will get all the even years. And then father will always get Father's Day and mother will always get Mother's Day. But this is just the general schedule, but holidays are definitely something to think about for custody. Like, let's say your family is really into Christmas, dad's family is really into Thanksgiving. Maybe you can just, every year dad gets Thanksgiving, every year mom gets Christmas. That's just something to think about. And the other thing when you're for custody is vacation time during the summer. Often, usually one parent will get 2 weeks consecutive, so that way they can travel with the child. Okay. So what we just talked about in the first part of this training is initially filing for custody after you have separated from a partner. The next thing I wanted to discuss was modification of custody. That means you've had a court order for, let's say, 4 years, and you no longer find it appropriate. You want this custody order changed, modified. So in order for a modification of custody to be granted, there has to be what the legal term is a change in circumstance. So a change in circumstance has to be pretty substantial. It can't be something like, well, it's just really, my child's older now, I just want to spend more time with them. The court's going to say, no, that's not fair. That's not fair to the other parent. It has to be something pretty major, such as, let's say you were a father and you only had 30% parenting time because of your work schedule. You were a truck driver. Now you've switched. You are now working remotely with flex hours at your job. That would be, and where you would be home and able to have the child 50% of the, half and half, no problem. That would be a change in circumstances that would warrant a filing. Another change in circumstance would be, let's say you have a 14-year-old daughter who has been with dad 70% of the time, mom 30% of the time. The teenage daughter is now saying, I don't want to be with dad. I want to live with mom. Mom just got remarried and has all these stepkids that I want to spend more time with. And the child is just refusing to go to dad's. Mom could file in that circumstance as a change in circumstance for the child's desire based on her age and maturity and spending time with half siblings. So what this comes down to is there has to be something major going on. So if you are a parent and you receive notice that the other parent has filed for a modification in custody, that can be really jarring and upsetting, but keep this in mind that that other party has to show the court that something has changed to take away your parenting time. It's not automatic. Just because a parent files it wanting a change in the custody agreement doesn't mean it's going to be granted. They have to prove to the court why this modification is warranted. Okay, so the other form of custody petition is an emergent petition. And essentially, like, once you file for custody, you're probably gonna have to wait 2 to 3 months for a court date. Unless you file it under an emergency, saying that we need to address this custody issue right away because this child is in danger. These are not usually warranted. Usually the court throws them out unless it is a major emergency. You are proving that this child is an immediate risk of physical or emotional harm. I can give for an example, let's say mom has a 5-year-old boy. 5-year-old boy comes home from visits with dad and says, I love going to dad's house because he has guns. I just love guns. I play with them all the time. They're so cool. And then mom is, what do you mean? Like real guns? Oh yeah, the daddy got a gun and doesn't put it away. that would be an emergency. File, change custody. It's not safe for that child to go to that home if father's leaving weapons out. That's really what the court looks at. It has to be something major. Maybe the 11-year-old comes home and says, Daddy passed out after shooting heroin. That's an emergency. That's not appropriate for the child to be in that home. Your child coming home and having a huge tantrum and saying, I hate daddy, not an emergency. So petition for relocation. It's important to note that if you have a custody order in place, or if you don't, but especially if you have a custody order in place and you want to move away to another state or within Pennsylvania, but an extremely long distance over 2 hours, you're going to have to petition the court for relocation. And because the court is likely to, you're not automatically granted the ability to move away with the child, because it's essentially taking a substantial amount of parenting time away from another parent. Now, if the other party, if I'm separated from my spouse, and I say I'm going to move to Louisiana, and my spouse says I'm fine with that, I don't care, I'll get him during the summer, and then there's a form that the other spouse, that the separated parent can sign and say I'm in agreement with it. That gets submitted to court, and you don't have to do this. Now, if I told my my ex-father of the child that I wanted to move to Louisiana and he said, no way, I don't agree with that, then I'd have to file this petition for relocation and ask for the court's permission to move to Louisiana. So there are numerous factors that the court thinks about when determining whether or not to grant a petition for relocation. The court doesn't want you to just be leaving the state because you want to get away from all this. You have to show that you have to move away because it's going to be in the best interest of the child and for your life altogether. So let's say if I had all my families in Louisiana, I'm going to have all this familial help in raising my child. I was offered a job down there where I'm going to make substantially more money and be able to provide better for my family. Those are all factors that would allow the court, would encourage the court to permit the relocation. It's a pretty heavy burden. The courts are not keen on allowing a parent, on permitting relocation, especially if there's a shared custody arrangement. It's certainly not an impossible burden to meet, but you really need to go into court showing why this move is in the best interest of the child. And again, getting closer to family, a job where the parent will be bringing in a lot more money, better schools. Obviously the school district in Philadelphia is struggling. So if you're going to New Jersey where the schools are fantastic, that would be something that would weigh favorably for a relocation. Okay, so does anyone have any questions so far? Just on the PowerPoint? Okay. So the other petition that you can file pro se by yourself is what's called a petition for contempt. A contempt petition is filed when you can file for contempt when the other party is willfully not obeying the court order. Now, willfully is an important word. If let's say your pickup time, dad's pickup time for custody is 5 p.m. at a Dunkin' Donuts. Mom gets there at 6 p.m. She had texted, hey, I'm running late. Filing for contempt would be wrong. You're not going to win that because that's not willful. Mom made a mistake. Maybe she should be more careful in the future. It only happened once. That's not contempt. That's not willful. Now, let's say mom just refuses to bring the kid. She says, you know what, Johnny doesn't want to go to your house this weekend. He wants to hang out and sleep in. I'm not bringing him. That is mom willfully denying the court order. And if, okay, she does it one weekend, then she does it again. Then we're 4 weeks, we're a month out and dad hasn't seen the child because mom is saying the child just doesn't want to go. He's tired. That would be a contempt. And if mom continues, even after you're trying to ask, hey, what's going on? What can we do? And they're refusing, that's where a contempt hearing filing for contempt would help. If the other party is found to be willfully denying a court order and they are found what is in contempt, the court will put in sanctions against that individual. Usually it's in makeup time, in which the parent who filed for contempt, who has had to deal with not seeing their child, will then get additional time with the child. Now, what to do if a contempt petition is filed against you? So there are what are called defenses to contempt. In order to have a true defense to contempt, you have to show that it was a serious safety concern. It would be detrimental for the child for you to follow the court order. For instance, let's say you have a 7-year-old and your 7-year-old was just diagnosed with diabetes, like type 1 diabetes, and they have to do all these insulin shots and training. And the other parent, and mom just doesn't care. Mom's like, oh, whatever, not wanting to learn about the medication, still giving the child cupcakes. That would be a defense to contempt. Maybe dad could say, well, I wasn't going to send my child there because it was a serious risk. Mom doesn't have any of the medications. Mom gives him candy. I wasn't going to put my child at risk of harm. That would be a defense to the contempt, because yes, you were willfully denying the court order, but you were doing it in the best interest of the child. I would suggest any family, any parent, if they are hesitant to follow the court order because of the safety for their child, before not following it, file for modification. You're not going to get a court date, but at least you can go right away, but at least you can go into court if the other party files for contempt and say, hey, I knew it was a danger to my child. I've already filed for a modification, and here's why. Okay, so child support and spousal support. First we'll go through child support. I suggest as soon as you separate from an individual, you file for child support. It's calculated, it's really formulaic. Each party is supposed to submit W-2s, pay stubs, so that way it goes before a hearing officer, has an understanding of how much each party is making. They will ask each parent a series of questions. Is the child in daycare? How much does the daycare cost? What are your weekly expenses? How much is your rent? How much is your mortgage? And they put in all that information and calculate it to a number. Usually they attach it to, they do what's called a wage attachment. So the child support, the obligee, the person who has to pay the child support, it just comes automatically out of their wages and into the bank account of the parent who's receiving it. If it's a true 50-50 shared custody schedule, and parents have similar income, child support will likely not be entered. If it's a primary and partial physical custody, child support will be entered. As far as custody, it's based on overnights. So the more overnights a parent has, the less they have to pay in child support. Enforcement. So if, let's say, child support has been entered, but they are just not paying, there's no wage attachment because, let's say, mom or dad is self-employed, a barber, that sort of thing, you can file for enforcement. What that will do is they will put punishments on the parent not paying, take their driver's license away, their passport, put in financial punishments, making them pay even more than they're already owed. Yeah, it can be difficult. And also jail time. If a parent doesn't pay, they can also be incarcerated for that. So that leads us to modification. If, let's say, you're a obligee, you have to pay child support. You are making $62,000 a year as a technician for the water department. Your child support is based on that income, and your skill levels as a welder, a plumber. You then have a major injury back, and you have a spinal disc. You can't work as a welder anymore without causing permanent physical and emotional damage. and the only job that you can possibly have is a sitting position as a greeter at Walmart, where your income now goes to $22,000 a year. You need to file for modification and child support immediately, because otherwise you're still going to be at the same level of owing child support and not able to meet it. And then you'll gain arrears and possible enforcement action. Now, modifications are not easy to get. You have to provide evidence. You need to get all your medical records for that injury. You need to get a letter from your physician stating it would be dangerous for you to do the job that you were previously doing at that financial level. These are not easy to win. They might be something where I would recommend someone getting an attorney, because the other party will fight it. And the hearing officers tend to really push people to earn at the level they were earning. Now, an obligor, a person receiving the child support, they can also file for a modification if they realize that the other parent got a new job where they're earning a lot more money, or if there's a change in custody in which that they're gaining even more parenting time and deserve more money consequently. Now, for spousal support, it's important to note spousal support only applies to marriage. So if you were cohabitating for 20 years, you're still very, very unlikely to get any form of spousal support. Now, if you are married and you officially separate, the day of that separation, you can file for spousal support or pendente light support. And it's essentially just a financial order from the court to assist you in caring for yourself during the separation period. It's not nearly as much as child support, obviously. This is not based on how many kids you have. It's not based on anything like that. It's based on simply the marriage and how the other spouse has to support the spouse that they're separated from. And it's calculated similar to child support, but at a much less significant level. Okay, so does anyone want a quick 5-minute break before we get into the next half? You want a break? Okay. We'll be back in how about 5 minutes? Does that work? Okay.
Just wanted to say that you don't need to how do you say that? So you don't need to disconnect. You can just turn off your camera if you want and stay muted, and then we'll just come back in. And you said 5 minutes, right, Kelly?
Yeah.
All right. Thank you. Thank you. That was great.
Okay, so if everyone's ready, I will get started. So the next thing I want to talk about was PFA, or a protection from abuse, which was all. If you do want to file for a PFA, you file it at the family court, 1501 Arch Street, 11th floor, just like you would for custody and child support, all of that. So the statute that dictates a PFA is 23 PA 6101. And it's based on the Protection from Abuse Act of Pennsylvania, which allows individuals to file for a restraining order against another person to protect themselves or their children if there is abuse present in the home. Under the Protection from Abuse Act, it also gives every individual who has filed for a PFA the ability to talk with a domestic violence counselor advocate after their filing. Sorry, my computer, there we go. So what qualifies as abuse under the statute? That's important to know. Because if just physical bodily harm and injury is not the only form of abuse. So some people feel like they have to wait to get a PFA until they've been physically hit or physically harmed, bruised, that sort of thing, or had to call the police. That is not the case. There are other factors that would qualify for a person to get a PFA, and certainly qualify as domestic violence under the law. False imprisonment is a section. What does that mean? It sounds really something out of Law and Order SVU. So false imprisonment would mean, let's say, as a part of the domestic violence and control, a intimate partner, a spouse, refuses to give the other partner any money, takes their car keys away, locks them in a room. That would be false imprisonment. If you make it so a person cannot leave their home because their car keys are taken away, they lock the car and the person's inside of it, that's all false imprisonment, in which a PFA would be qualified for. Placing another in reasonable fear of imminent serious bodily injury. So the key word there is reasonable fear. So let's say your partner says, "God, I just want to kill you." Obviously, that's not a nice thing to say, or "You're such a bleep, bleep, bleep." Is that a reasonable fear that you're going to be killed? Well, you want to go to the court and show why it's a reasonable fear. Does the person that says, "I want to kill you," have access to a weapon? Do they have guns in the home? Have they threatened you before? Have they physically harmed another person to the point of serious bodily injury, where if they did it to that person, it's reasonable to think that they're going to do it to you based on that statement. If, let's say, harm is increasing, or they've injured an animal, all of those go into factors that would make a reasonable person be fear for their life. Also, let's say it doesn't even have to be verbal. Maybe the partner is pretending to shoot them. Again, my 3-year-old will pretend to make a gun. That wouldn't be reasonable. But if the person doing it has perhaps been arrested in the past for assault, they have access to a weapon, their aggression and violent behavior has been increasing, they're harassing through text messages, emails, all of that is important to note. Rape, in like any kind of sexual assault, all of that qualifies for a PFA, including spousal rape. If parties are married and the other person forces them to have sexual encounter and they don't want to, that would be abuse under the PFA law. Also, if a intimate partner harms your child, that would qualify for a PFA. You can file for a PFA on their behalf. So let's say I get into a relationship with a new man. He drinks to the point of intoxication and shoves my son down and hurts him, and I'm scared for my son going forward. I could file for a PFA on behalf of my son, or if the violence is directed at my son in myself, I could file for a PFA and have my son attached to that PFA. Okay, any questions on also verbal abuse qualifies. Again, it just has to be reasonable that you would be scared for your safety. So yeah, and as far as evidence for a PFA hearing to show that the requirement is met for abuse, the evidence that the court will look at will be obviously any medical records, if there is actual physical harm, police reports, if the police were contacted, photographs of the injury, and text messages, emails, if it's terroristic threats or threatening of serious harm, the court will look at all of that, as well as your testimony. If you file for PFA and you don't have any evidence, you can still get a restraining order if you tell the judge what's going on, why you're scared, why you think your life or your is in risk, and why your physical why you're at risk for injury. You can also bring witnesses. So if, let's say, you don't have any, there's no medical records, there's no police reports, anything like that, but you've been talking about the abuse and your fear of your partner to your coworker for the past 6 months, or the coworker saw overheard the way he talks to you on the phone, or perhaps after you got punched one time, you went and told your mom and she saw the injury. Definitely those individuals would provide great evidence. Okay. Okay, so who can bring a PFA? So you have to have a statutorily defined relationship against the person that you're filing a restraining order against. It has to be a spouse or a household member or an intimate partner. So what that means, essentially, if you're living with someone, you're going to have that requirement. But let's say you are in an apartment complex and you're getting harassed and threatened by the guy who lives three floors up. You're not going to get a PFA or a restraining order. That's not the required relationship under the law. You have to be a household member, a roommate, or an intimate partner, former or current. So obviously, if you're dating someone and they live 30 minutes away and they're threatening you, yes, that qualifies, whether you're together or broken up. Okay, so there's a procedure for a PFA. It starts with a temporary, in which you would, the minute you feel threatened, scared, some incident happened, you want to go to family court, file for a PFA, and within 48 to 72 hours, you're going to go before a hearing officer or a judge, plead your case as to why you feel threatened, and a temporary PFA will likely be issued. The threshold for a temporary is significantly lower than a permanent PFA. You just have to show the most basic evidence. It's not a high threshold because it's not permanent. It lasts for the period until you have a trial before a judge, which will be 2 to 3 months. If a temporary PFA is issued, it will be served by a sheriff's officer onto the other party, and they will be required to come to the final PFA hearing. Now, when I say final, it's not really final. PFA in Pennsylvania lasts for the maximum of 3 years. Now, PFA hearing, although you may think it sounds very criminal, protection from abuse, it's not, still a civil hearing. It's not beyond a reasonable doubt. criminal standard. It's the preponderance of the evidence. In other words, the person asking for the PFA has to show that it's more likely than not that the other party was abusive and committed those actions in which they require a restraining order. So you don't know the other party, the defendant, and the PFA is not going to be given a lawyer. Both parties can go forward unrepresented. You don't have to have an attorney. The individual filing the PFA will often be offered a domestic violence advocate as per the PFA statute. A domestic violence advocate is a volunteer through various organizations in the city that work with victims of domestic violence. These advocates will provide resources to that individual for safety precautions, whether it be a women's shelter, or therapy, that sort of thing they can assist with. And the domestic violence advocate will be offered to the person filing the PFA, even if they're not granted the final protection from abuse order. Okay, so the next part that we're going to talk about is grandparent custodial rights. So this is, let's say you're a grandparent and you want to get visitation or custody of your grandchild. Which, I mean, I know in my own personal life, my parents are practically other parents to my children. So grandparents really do a lot for families. However, grandparent visitations are not, and parenting time is not automatic. But however, in the state of Pennsylvania, there is a Grandparents Visitation Act, which provides grandparents some rights to getting visitation with their children, with their grandchildren. In order for grandparents to be able to file for custody or visitation, certain aspects have to be met in order for the grandparent to have standing to make the claim. Standing just means that the court says, yes, you are permitted to ask for custody. If you don't have standing, then you can't even bring the claim for custody. So in order to get standing, the one way is that the grandparent's own child is deceased. So let's say there's a 3-year-old the father died of a drug overdose. The paternal grandparents would have the standing, the right to make a custody claim for shared or visitation with the grandparent because they're with the child because the father is deceased. If parents have separated for a period of 6 months and up for a divorce period and are planning on getting a divorce, grandparents can file for visitation. If a child has resided with the grandparents continuously for 12 months, and then a parent takes that child away, the grandparent has standing to bring a custody claim for visitation. So an example for that would be mom and dad of two kids live with maternal grandparents for 2 years while they work because they don't have housing. Those parents get housing, take the child away, won't let grandparents visit at all. Because the child had resided continuously with the grandparents for 2 years, that would give grandparents the right to file for visitation and partial custody of that grandchild. However, in all those circumstances, the grandparent has the burden to show the court that it is in the child's best interest that the grandparents have visitation. It's definitely a higher burden and more of a battle for grandparents to get custody rights. So even if you have standing, a parent, like I said, if one of the biological parents is deceased and grandparents have standing to bring a custody claim, the grandparent still has to provide evidence to the court why it would be in the child's best interest for them to have visits. Okay, so here are just a couple case examples that I've seen where grandparents were given custodial rights and when they were not given custodial rights, which you're welcome to read over. Kind of what we just talked about, like one example where the grandparents were awarded partial custody of the grandchildren. The bio mother was killed in a tragic car accident. Bio father was not allowing maternal grandparents to see the child at all. The maternal grandparents were able to file for visitation and partial custody because the child's mother, their child, had passed away. A situation where grandparents were not granted visitation, where the grandchild's parents got divorced, but then they reconciled and decided they didn't want maternal grandparents to have any visitation with the child. Grandparents did not get visitation because the bio parents were a united front. They didn't want grandparents involved, and they're allowed to make that decision, given that they are the parents and they have the stronger constitutional rights to determining who has the right to have a relationship with their child. Okay, so when can a grandparent obtain custody, like either full or primary custody of a grandchild? For that to occur, it has to be pretty substantial abuse or neglect under the law by the biological parents. In other words, the grandparents have to show that their grandchild is at serious risk of neglect or abuse because of parental actions, whether that be drug abuse, mental health concerns, and the grandparent has to show that they have a strong, substantial relationship with the child. So here's an example for that situation. I did a case where biological mother had severe bipolar disorder and schizophrenia, as well as self-harming behavior. The maternal grandparents filed for full custody of the child because of mother's unstable mental health history. They had to present to the court mom's diagnoses, her irrational behavior, police reports when the police were called because mother was having an episode. And so they had to submit substantial evidence to show why mother was an unfit parent. And they also had to establish that they had a great relationship with the grandchild, and that the grandchild had essentially another parent role in the grandparent. This can be a really great option to avoid DHS or child welfare involvement. If you're a grandparent and you have serious concerns that maybe your child or your child's partner is struggling with substance abuse or financial poverty, you can file for custody of that child. You don't have to call DHS and get them involved to remove the child and put the child in your care. You, as a grandparent, can petition the court to get custody based on your child's unfit status. I definitely recommend grandparents do this route if they have concerns for their child or their grandchild because of parental abuse or neglect, because essentially then it gives you, the grandparent, all the rights to take care of the child, and it gives the biological parents time to get their stuff figured out without court involvement from DHS, where it can result in termination of parental rights and be a long court battle. Okay, so one thing I've seen come across a few times is when DHS has been involved with biological parents and the biological parents' rights are terminated and the child moves on with adoption proceedings. The grandparents of the biological parents whose rights were terminated may want to have visitation and continued contact with the child. Unfortunately, that's very difficult and usually doesn't happen, because once the biological parents' rights are terminated, it takes the grandparents' rights away as well. However, if the grandparents foster their own independent relationship with the adoptive family or the foster family, they can make an arrangement and write a visitation schedule and have it notarized and submitted under as like a contract. Okay. So the last part I wanted to touch on was DHS and child welfare investigations, because unfortunately they happen quite often in Philadelphia, and sometimes people just don't know how to respond to it. So how DHS becomes involved with the family when there's a report by an anonymous individual stating that there's abuse or neglect going on in the home, whether that be inappropriate living conditions for the child, unstable housing, drug and alcohol abuse, or physical and sexual abuse. So the first thing to know is if DHS comes to your home, that does not automatically mean at all that they're going to take your child or that you're going to become court involved. DHS starts by doing an investigation in which they interview the child, they do a home inspection. Home inspections, they will look at what food is in your home. It can be very invasive and painful, but I always advise families to just be upfront, be honest with the investigators, let them in, cooperate. It always works out better that way. And it's also important to know that if the only issue is housing or lack of electricity in the home, heating, they should not take your child for that. What you should do as the parent, if you have DHS involved because of a housing or poverty issue, to ask DHS to help. They have funds, they have money set aside to pay to restore electricity in the home, to restore heating in the home, to get bedding or whatever is to exterminate bed bugs if that's an issue. DHS's primary concern should be keeping children in the home and maintaining the family. And if DHS does become involved in your life, use that to your advantage. Say, you know what, I agree, I'm struggling right now. I do need help financially for this, this, and this. DHS has money set aside that they should use to assist you with that. And there's also a difference between being court involved and not court involved. Even if DHS says we want to serve you, that doesn't automatically mean it's going to go to court and your child will be put into placement. And the other thing to note is that if DHS or children and youth come and investigate your home, they're not going to report you to immigration if your status is affected. That those are two very separate entities. And as for status, if you're undocumented or do not have legal status, everything that we've talked about already, you can do. You can file for child support, you can file for custody, you can file for a PFA, you can do all of that without legal status. So do not let your immigration concerns impact you fighting for your children. And obviously, if you suspect, and like we just talked about, obviously, if you suspect serious child abuse or neglect, you can contact Childline of Pennsylvania or the Department of Human Services of Philadelphia. I recommend notifying the Childline of Pennsylvania first because I think their organization is more efficient. However, as we previously discussed in the grandparent visitation section, I recommend if you are a grandparent and you have concerns about your child's behavior and your grandchild's safety, to petition the court for custody instead of getting DHS involved. Because as you can see, once DHS is involved, you have a whole other court system and statutes and laws and goals that the parent has to deal with. If the grandparent has custody, then you're protecting the child and giving mom and dad the ability to work on whatever issues they're struggling with without the demands of court.